Okay, so under Article 2(3) of the New York Convention, do you think there is a substantive contract law? The New York Convention is supposed to be a procedural treaty. Procedural in a sense that it is for the enforcement of the agreement and the enforcement of the arbitral award. But somehow, very interestingly, under Article 2(3), when it says, unless it finds that the said agreement is null and void, inoperative and incapable of being performed, do you think it's actually providing a substantive rule of decision about the validity of contracts? What would have been an alternative way of formulating this rule? If they didn't want to provide substantive rules on contracts and they wanted to leave it for the domestic contracts laws of each contracting state, what could have they said instead of talking about invalidity, voidness, things like that? What would have been an alternative, a possible alternative formulation of this rule if they had really intended to leave that decision to the substantive laws of the contracting states, or whichever law that the parties have selected? They could have just simply said, like what Kansas said here, right? Save upon grounds exist of law or an equity for the revocation of any contract. Something like that. Or even omit equity, say, as grounds exist under the domestic laws of the contracting states. Right? Instead of that, they actually go on and provide very specific substantive rules of decision about when an arbitration agreement is said to be invalid. Right? Do you find that interesting? Because this is supposed to be a procedural treaty. They weren't supposed to be modifying contract laws of contracting states. Now, in the United States, in the cases that we just read, these terms have been interpreted to mean one of those four things that we just talked about. So that is, then do you think then that there would be more harmonization across contract laws about validity of the arbitration agreement rather than the validity of any other types of contracts? So in other words, does an arbitration contract, is an arbitration contract considered a unique type of contract with its own international rules of decision? That is really what it makes it, because they decided to include these provisions. Because as we talked about last time, the main purpose of the New York Convention is to make sure that awards are enforced when they are made in state, they are enforced in state. So initially that was the only thing that they were thinking about, and then they added the enforcement of the arbitration agreement itself, and then they elevated it to being presumptively valid, and then they added substantive rules of decision to it. Because without that first stage, you're not going to get to awards level. And as we said last time, the reason why the enforcement of arbitral awards are easier than the enforcement of court judgments is because of the New York Convention, except for the European Union, it's very difficult to have a court judgment enforced in the country. Depends on reciprocity and existence of bilateral court judgment enforcement treaties, things like that. So what started as the enforcement of the award has become this robust enforcement of agreements. And what that does is it resolves all sorts of jurisdictional problems that we talked about last class, because it's presumptively valid and subject to some international standards for its own validity. In other words, courts cannot really add 100 different grounds of invalidity, because the grounds of invalidity have to comply with the New York Convention of null or inoperative, incapable. So that is where we are now. Let's consider the remaining two cases. Again, this is a French Court of Cassation case, 1994. Starts on page 182. Let's identify the facts of this case first, as it relates to the agreement only, the arbitration agreement. First, was there an arbitration agreement?
Yes, but in the annex.
Yes. So the arbitration agreement was contained in an annex. Was it signed? It was not signed. Was there another provision on dispute settlement? What was that dispute settlement provision? And what does it say?
The dispute should be settled by the court under deviant court and deviant law.
Exactly. So you have two competing dispute settlement provisions. It's not uncommon, by the way. When you sign, have you seen these mega project contracts? In any, are you familiar with? What do you think? How many pages do you think are these contracts?
More than 50.
Huh?
More than 50.
More than how many?
50.
50. Yes. Well, they run into hundreds and sometimes thousands of pages for major projects, and including annexes and 100 different annexes, things like that. Very complicated, right? Moreover, the same parties could actually agree to do a number of different projects together. One set of contractual documents contains some provisions that are not in these other documents. Sometimes dispute resolution clauses or dispute resolution provisions get lost, and people cannot keep track of what is included in what document. 30 lawyers working together to put these kinds of, there's financial instruments, there are, construction documents, things like that. They get messy. So what happened in this case was somewhere in the main body of the contract, in the general conditions of contract, there is a clear provision that actually selects a forum. What is forum selection? When we say a forum is selected, are we talking about arbitration or court?
Court.
Yes. It is a specific court that is selected as the forum where the parties shall resolve their dispute. This was in Tripoli, Libya. This is in the body of the contract that is properly signed. But somewhere there was an annex that actually selected what type of arbitration? ICC arbitration. Where?
Paris.
In Paris. And hence why it ended up before the French Court of Cassation, right? That is the seat of the arbitral tribunal, and the seat of the court of the seat of the tribunal would have jurisdiction for annulment and things like that. So the Libyan guys are the ones who wanted to go to their own court, and the foreign party is obviously the one who wanted to go to arbitration in Paris. The question then became, about what?
Whether this proposal is valid.
Which one we should follow?
Yes, obviously that's the one, right? But next to that, whether or not the court should go to arbitration is fundamentally a question of what? Huh?
Validity of arbitration
Exactly.
because
It's
of
the validity of the arbitration agreement. It is fundamentally the question of whether or not the arbitration agreement is valid. And secondly, is in a more subtle way, even if it is valid, does it supersede the form selection clause contained in the main body of the contract? By the way, this is not unusual. You can have multiple conflicting dispute resolution clauses or provisions in complex contracts. That could be grounds for malpractice on the part of lawyers who actually did the work, but it happens all the time. And tribunals are confronted with those kinds of questions. So, what happened in this case?
they compel arbitration.
Which court compelled arbitration? So there are different routes that things could take, right? Here again, so our example again is here's an example. When the parties have conflicting interests, one wants to go to court, another one wants to go to arbitration. If we sequence this, it's possible that A may initiate a legal action first. Right? It's also possible that B does what?
Go to arbitration.
Exactly. Initiates arbitration first. Right? So if B initiates arbitration first, let's take it this way. We talked about it. If A initiates arbitration first, B objects, and then court refers the matter to arbitration if it determines that the arbitration agreement is valid. That much is clear. But if B initiates the arbitration first, what do you think happens? What do you think A would do?
Initial
A could actually do one of two things, or maybe both. A could actually go to court and ask the court to compel B to appear before him. Or A could just simply arbitration and then say what?
We have the deal.
is invalid. So we should go to
Huh?
Form selection clause is valid and jurisdiction.
Exactly. So it would raise a jurisdictional objection. Says there is a valid form selection clause, therefore you cannot arbitrate this matter. And that becomes a jurisdictional question. A would be making a jurisdictional argument before the arbitral tribunal. Tells the arbitral tribunal, listen, there's this valid arbitration, valid form selection clause. That means in this particular case, you don't have jurisdiction to arbitrate. Now, consider this. There are two possibilities, right? Here, the tribunal might agree with A's objection, dismiss the case, in which case a court case would proceed, right? In tribunal. The second possibility is that the arbitral tribunal would reject the jurisdictional objection and arbitrate the matter and issue an award. If the arbitral tribunal issues an award without having the jurisdiction to do so, because it's they who say we have jurisdiction, no parties involved so far, under the New York Convention and many national courts, the losing party would have the opportunity to challenge the validity of that ruling or the award in a process called annulment or set aside. We will study that. Say the arbitral tribunal never had the jurisdiction to adjudicate in the first place. I want this court to see if they have the jurisdiction. If they lack the jurisdiction, the award would be annulled, set aside. It would be of no effect. If the court agrees with the tribunal's jurisdictional decision, then the court would enforce it or at least not set it aside so that other courts would enforce it. So what happened in this case is not the first, it is the latter. So an arbitral proceeding was commenced. They went along with it. They did not like the outcome. They tried to set it aside. Where? At the place where the award was made, which was in Paris. That's why it ended up before the highest court in France. Then when the court was asked whether or not the arbitral tribunal had jurisdiction to decide in the first place, they had to conduct what is called a de novo review of the jurisdictional question. If they had determined that the tribunal didn't have jurisdiction, then they would have annulled the award and they would have sent the parties to Tripoli to adjudicate the controversy. Now, consider the following question. What was the applicable law in this case for the determination of whether or not the tribunal had jurisdiction? What did the Court of Cassation in France do? What law did they apply?
New York Convention. New York Convention.
Which one?
New York Convention.
The New York Convention, it would be, yes, but if you look at the last paragraph on 183, the last paragraph of that case, the case where the paragraph that starts, but whereas, what did they say? Do you find that statement interesting? Huh? What law are they telling us? What law are they applying? Whereas according to a substantive rule of international arbitration law, does such thing exist? Could it exist? An arbitration clause is legally independent from the main contract in which it's directly contained or referred to, and its existence and efficiency are assessed according to the parties' common intent. Common intent, no problem, and without necessarily referring to a national provision, provided that mandatory provisions of French law and international public policy are not violated. That's all they care about. That's what the court says, right? All we care about is as long as it does not violate French law, public policy, all we care about is the common intent of the parties. Look, the first paragraph tells us, Article 32 of the standard conditions of the contract provide not only for the application of Libyan law to the contract, but also for the exclusive jurisdiction of Libyan courts. So you have that. Libyan law applies, Libyan courts must adjudicate this controversy. And then you have the Supreme Court in Paris saying, oh, wait a minute. The applicable law is this rule of international arbitration law. We don't care as long as it's not inconsistent with French public policy. What do you think about this decision? It's obviously pro-arbitration, right? Extremely pro-arbitration. And does it cross the border into being exorbitant? Very, very pro-arbitration. Now, I want you to raise your hands and tell me 3 problems with this decision. 3 issues that you might see just from a logical standpoint that you disagree. What have they done in this decision? They obviously upheld the arbitration award, right? Let's explore what could be problematic. Yes?
First is, as you mentioned, that there is no such international arbitration rule.
Exactly. That is very interesting when they say rule of international arbitration law. It's not very clear what they mean, and something like that would not be, ordinarily, would not have any meaning. What else?
And second, they mentioned that we should, according to the French law, but it disregard the Libyan's law, but I think they are in equal standards. If you ignore the Libyan law, you should also ignore the French law.
So yeah, there is clearly selected Libyan law. They didn't want to pay attention to that. They just completely disregarded it. And they said some French law related international rules apply, but at the same time, they did not very specifically say French law applies. They only refer to French law to say that as long as the tension of the parties is not inconsistent with French public policy, it should be given effect. So in a way, they were trying to determine the intent of the parties rather than anything else. What would be the third problem? Just from a logical standpoint.
Party common intent is under dispute. So I think maybe according to the party's common intent, they should not go to the arbitration because one party wants to go to the court.
So exactly, the intent of the parties was ambiguous, at least, right? Because they wrote 2 different things. 2 different things. There are 2 mutually inconsistent, exclusive things that they wrote in the contract. So the intent of the parties was not very clear. And is it a question of fact or a question of law?
Fact.
It is a pure question of fact, whether they initially intended to arbitrate or to go to court. Because on the one hand, there is a signed provision that says they shall go to court. There is an annex that is not signed that says they shall go to arbitration. Maybe they did not have meeting of the minds. One was thinking arbitration, the other one was thinking court. Or maybe they knew exactly what they were doing. Maybe the party who wanted to arbitrate probably didn't get its own way and just annexed it, and it didn't matter for them, so they were probably saving this idea, oh, we have that annex, it wasn't signed, we didn't sign it, but it was already mutual intention. So that is why it appears to me that the court was convinced, that the parties at least says that it was convinced that the parties intended to arbitrate, and therefore the arbitration agreement must be given effect. And I'll tell you, a dispute that I've been involved in, containing more or less the same kind of problem. It's interesting, and I can. Some of this is public, so I can talk about it. It was a dispute between an African state and a Chinese company, and it's a Hong Kong Chinese company. Both are parties. It's an oil and gas dispute. I don't know if you've heard of production sharing agreements. When oil companies go out to develop oil fields, they sign what is called production sharing agreements. Petroleum production sharing agreements, PPSAs. So the government that I was representing had signed 5 PPSAs with a big Chinese company and some owners from Hong Kong. 4 of the agreements did not contain a very, very crucial provision, Article 3.1. Article 3.1 was a condition for the performance of the contract. It's very essential. I cannot tell you what it meant, what it said. Now, I was lead counsel in that case, and I was talking to the minister who actually signed it. This is a big case, it's $1.5 billion. And she said to me that she thought that each one of the 5 PPSAs contained 3.1. The Chinese company was represented by New York lawyers, and only one of the 5 contained 3.1. And she said, if I had known that the 4 contracts did not contain 3.1, I would not have signed the whole contract. She said it did not make any sense to me. And I asked her, so why did you think that all of them contained 3.1? And she said, I told the lawyer specifically that he should put it in each one of those 5 contracts, and at the day of the signature, he picked up the one copy, showed me 3.1, and put it back. And I signed all of them, assuming that 3.1 was included in each one of the 5 contracts. That actually led to a dispute that took 4 years to conclude for $1.4 billion, where there were many subsidiary issues. So the hearing was in Zurich. She came to testify. And the lawyer who put it in there also came to testify. He's a New York lawyer. And I had the opportunity to talk to him, to cross-examine some of my colleagues. And the CEO of this company also came to testify. So there was an interesting factual dispute. And the CEO said that I never agreed to include 3.1 in 5 contracts. I only agreed to do it in 1. And she comes and says, no, I told him specifically that if he did not agree to 3.1 in each one of the 5 contracts, I would not sign the contract. When it's he said, she said, what do you do? So yeah, these things really happen. So I would not say what happened afterwards, but this was the dispute. This is actually reported. It's in the media. But I thought that was really interesting. There were other witnesses who talked about how 3.1 was so essential to the whole thing, and without it, they could not have entered into the contract. So these are the kinds of things that you see in arbitration. The factual aspect of it is usually more important than the legal aspect of it. And that's exactly what happened in this case. They had these two conflicting and people come and testify. So the court had to decide which one to believe, basically. All right. Let's go to the last case for today, which is the hotels.com case. It is also a very interesting case. Let's develop the facts slowly and tell me who was suing whom and for what reason.
Literary companies who were his distributor and his competitor.
Exactly.
You know,
Both, right?
yeah, both.
Yeah. This is what Zeus is a. This is the little guy, right? Hotels.com. I'm sure everyone knows it. So Zeus sues Hotels.com plus this guy Limited. Is it Hotels Limited? Yeah. This is an Israeli company. This is also an Israeli company. And they were suing Hotels.com for what cause of action? Huh? Breach of contract. What did they do to them? So the distributorship was exclusive? And in breach of that, they gave it to this other guy? Right? So, where did they go? They initiated a legal action in Israeli court. District court. This is exactly what happened. Zeus joins these two and goes to court. If there is a valid arbitration agreement, the party who wants to go to arbitration obviously objects to the jurisdiction of this court and asks this court to refer the matter to arbitration. Right? And that's exactly what they did. The problem was what? So we're talking about this contract, right? The breach of this contract. Was there a contract between Zeus and Hotels Limited?
No.
There wasn't. And the lawsuit against Hotels Limited is based on what? If it's not contract, what is it based on? Huh? Huh? Torts. Exactly. It's extra contractual. It's interference into their contractual relationship. So it's not based on contracts, it's based on torts. So there is a tort cause of action against this party. There is a contractual cause of action against this party. Unfortunately for Zeus, the contract contained what? An arbitration clause. Then, suddenly they had to defend a legal action about the validity of the arbitration agreement. Because if the arbitration agreement is valid, they cannot sustain the legal action here. They can sustain this only if the arbitration agreement is found to be invalid. Did they complain that there was mistake? Did they complain there was duress, waiver, undue influence? So what was the problem about this particular contract? What was the problem about that particular contract, the arbitration agreement? Huh?
Special reason. I think it's
Special reason.
It's
Yeah, they said special reason.
It's not concerned by the parties that is under dispute. I mean the hotel limited. So the hotel limited think that because they not concerned about this arbitration, so the arbitration is void.
Exactly. So there was actually no problem with this. There was no problem with this contract. They did not say there was a problem. The problem was this, the absence of a contract was this one. So what do you do? When the cause of action is closely intertwined with a breach of contract by the main guy, and the second offender is merely an accomplice, basically, what is the option that they have? If they had not sued them here, would the court assume that there was no contract here? There was no valid arbitration contract. Would there be any obstacle in initiating a legal action before the Israeli court against both parties? Would this be improper joinder? No, it wouldn't be an improper joinder. This is perfectly joined parties, the same cause of action, same kind of offending behavior. So the most natural thing to do would be to join them and sue them in the district court. Presumably, the district court would have jurisdiction over both parties. Hotels.com obviously conducts business in Israel. And of course, this is an Israeli party, right? The court has perfect jurisdiction, no problem. The only way the court would lack jurisdiction if there is a competing arbitration agreement, and if the arbitration agreement is deemed valid, then the court must refer at least the party that is bound by the contract to arbitration. Again, the problem is there is this other guy with no contracts, but the cause of action is interlinked. What do you do with that? That was the question that the court was confronted with. There are at least two possible resolutions to this issue, right? Or maybe three possible resolutions. Let's explore each one of them and which one the court picked. Tell me, hypothetically, what possible resolutions existed to this problem? One obvious resolution would be to let this go. Second possible resolution is what? Split, exactly. You go to arbitration, you guys go to court. That's where stuff resources. Why not? But that is a possible resolution. But neither one of those was acceptable to the court. Right? What did they eventually decide? Arbitration, right? Both parties or?
Both parties.
Yeah, that's the interesting part. The party that does not even have a contract is compelled to arbitrate just because he's sued with someone who does have a contract. How did they arrive at that conclusion? What is the legal analysis that got them there?
According to the law, only three situations will lead to arbitration invalid. That is inoperative and incapability and valid. So none of these situations appear in this case. So the court thinks that the arbitration clause is valid. So they compel the
Yes.
arbitration.
So, look, it's a very clever way of framing the issue for a court who wants to compel arbitration. they considered the issue to be about the validity of this particular arbitration agreement. They said the issue is about the validity of this arbitration agreement. You are telling us that this arbitration agreement is invalid because of the presence of a third party. The grounds of invalidity of an arbitration agreement are limited to null and void, not really incapable of being performed, because Israel is a member of the New York Convention. And they have included that in their law. Previously, they had a law that said special conditions. They said that does not apply to this because this is an international agreement and this is an international arbitration. And Israeli law for international arbitration is consistent with the New York Convention because the New York Convention is a part of Israeli law. So if the question is conceived as or framed as the validity of this particular agreement, and what Zeus is arguing is this agreement is invalid because there is a necessary second party. See? That is not a recognized ground of invalidity under Israeli law and under the New York Convention. Zeus itself gave them that excuse, right? Why? Because Zeus sued Hotels.com in Israeli court. It cannot do so because there is a valid arbitration agreement. That's why they said the question is about whether or not the agreement is valid and whether or not the existence of a second party makes this invalid. They said, no, that does not make it invalid. The grounds of invalidity are limited and limited to those three things. So the existence of the second party does not invalidate this contract. And if this contract is valid, you cannot initiate a legal action against Hotels.com. And if you cannot initiate a legal action against Hotels.com, you cannot sustain this particular lawsuit. We're not going to tell you that you cannot sue this guy in your court. You may, but not at least this one. So the most sensible course of action would be to go to arbitration against Vodafone. Is that a sensible outcome? What would you have to do?
About whether the arbitration that buying the original party also buying the third party. But here the court just interpreted that whether the third party will violate the validity of the original arbitration. But I think it's not that issue. It's about whether the binding arbitration also binds the third party.
So the question should have been framed as whether or not this actually also bound this one, yes, as a third party to this agreement.
Yes.
We'll talk about how non-signatories, third parties, are bound by an existing arbitration agreement. One of those instances is whether this is a third party beneficiary, or there is some kind of corporate interconnectedness, or there is some kind of approval waiver, things like that. So in this case, they obviously didn't want to frame it that way. They obviously wanted them to go to arbitration rather than splitting the cases into two, one going to court, one going to arbitration. But obviously, it's a very unsatisfactory result. Maybe they were confronted with a very serious problem that they have to choose one of the many unsatisfactory results, or the list of, let's say, of all the options that we have. So let's briefly review what we tried to accomplish today. We started out with the New York Convention. It's a provision that actually says that is Article 2(3). The contracting states, when seized of an action, the courts of a contracting state shall refer the parties to arbitration unless it finds that the state agreement is null and void. Now, for capable of performed. That is the basis of the presumptive validity of the arbitration. We talked about what presumption means, how the burden shifts, and the sources of law on which one can rely for the invalidity. The party that wants to go to court must prove that the arbitration agreement is invalid. Right? And then we used at least 4 cases to demonstrate the wide variety of ways that this question arises. We looked at this old case from France, 1843, the Prunier case, the Tremaci case, and of course these First Circuit and another case from Israel, the Hotels.com case. All of these cases show you the sometimes complicated set of circumstances that this whole presumption comes into play, what kinds of grounds of invalidity are involved, and what kinds of laws apply, and how they apply them. They sometimes make sense, they sometimes make absolutely no sense, right, at the end of the day. So let's conclude by, I would like to ask you a question about which one of these outcomes make sense to you and which ones do not.
The third one makes more sense.
The second one.
The third one.
The third one is probably the most serious offender, right? Because there was a contract, and then of course there's the annex, and of course is extremely pro-arbitration, and they even say that there's this rule of international arbitration law they basically invented. We'll talk about that theory going forward, but yeah, I would agree with you that this is probably the least sensible. And which one makes the most sense? Sending the Puerto Rican poor guy to Italy? Or the French insurance case where they say, oh, you don't bring all these poor people to Paris. And then say, if the law says 3 arbitrators must be named, you should name them. If you fail to do so, the law is, the agreement is invalid. Or the Zeus case where they say, if you want to bring in another guy, you can still go to arbitration even if that third guy is not found. So that is just a demonstration of tribunals and courts are all over the place. But what we need to just study is actually the basic principles and how they get there. Basic principle is presumptive validity. The grounds of invalidity are limited. The New York Convention not only provides for procedural rules, but in this particular case, it also sets forth specific substantive rules for the decision, the determination of the validity of the agreement itself. And most courts around the world have actually relied on those grounds in considering them a closed list of grounds of invalidity of contracts. And in the United States, as we said, it's fraud, mistake, duress, and waiver. Those are the grounds of invalidity. And under the FAA, the first section, as we saw from the council's law, has grounds that the grounds of the existing law and equity is under section 2, which is the New York Convention version of it. It's limited to those four, unless you can prove the existence of those four, the arbitration contract is considered valid. What it means is if the agreement is considered valid, court would have no jurisdiction to adjudicate. It must or it shall refer the matter to arbitration. Okay?